All right, I think hopefully everyone is back on after our quick break and ready to keep moving forward. We are fortunate here today to have Greg McLaughlin here to speak on public charge and family matters affecting citizenship and removability. He is going to be talking to us until the lunch break and for a presentation that was originally going to include Kate Lincoln Goldfinch, but unfortunately she was unable to be here today. So Greg, though, has a wealth of information and I know a fantastic presentation to lead us into the lunch hour. So I will turn it over to you at this point, Greg.
Thanks very much. So we did a little bit of a last minute pivot here since Kate wasn't able to make it. So my name's Greg McLaughlin, and I've spent the last 10 years of my practice focusing on representing green card holders in federal litigation to enforce the Affidavit of Support. And that's what we're going to be focusing our time on today, away from classic public charge issues and pivoting to the enforceability of the Affidavit of Support, looking at the nitty-gritty of how that happens, because Texas is one of several states where this Affidavit of Support can be enforced both in federal court proceedings and also in family law court. Unless you write me off as a Yankee, I will spit out some Texas bona fides. I am admitted in the northern and eastern districts of Texas, shortly in the southern district as well, as soon as they sign off on my admission. But more importantly, I know that you do not put sauce on brisket. Before we get started here, I'm sorry, I tested my mic before we got started, so I'm pretty sure that the volume is okay on my end. Is anybody else having a hard time hearing me? If so, let me know in comments and I can change. Before we get started here, it just would not be right to proceed without acknowledging the 19 children who were gunned down this week. 19 fourth graders. So if we could, before we get started, take just 30 seconds of our time to think about the children in our own lives who look to us for care and support. Just 30 seconds. Whomever you're thinking of, I know that every one of us would do anything necessary to ensure the safety of the children we care about in our own life. And especially those of us who are charged as lawyers with the just administration of laws in this country, we have got to close the distance between the care that we have for our children and a reality where they are safe to be dropped off at their schools. Okay. Let's get into some law here. I know we have today a mixed audience of folks who are immigration specialists and also folks from the broader immigration bar. So I'm going to take a few minutes for those without an immigration background to give a description of what this Affidavit of Support even is, how it arises in immigration law. Then we're going to talk about the legal obligations of a sponsor who executes one of these affidavits of support and get into how it is that the beneficiary of the affidavit, who is the foreign national, enforces this thing, which it turns out is a binding financial contract. U.S. immigration law, really almost forever, since the very earliest federal immigration statutes. And if you want to go back before that, even when states were in charge of administering immigration law, has always prohibited the immigration of folks who are deemed likely to become, quote, a public charge. What does that mean? Basically, it means those who are determined to be likely to be reliant on public resources. As that is currently codified under immigration law, it means those who are likely to receive and be dependent on means-tested public benefits. So longstanding provision of immigration law, you are inadmissible if you are likely to become a public charge, meaning dependent on public resources. It has long been the case in immigration law that a petitioner, somebody bringing somebody into the United States, could sign an affidavit of support attesting to the fact that they would take financial responsibility for the intending immigrant. Those documents, however, were not legally enforceable. In 1996, Congress was doing two things. Congress was looking at our welfare system, and it was simultaneously massively revamping immigration law. You can like it, you cannot like it, but one of the policy decisions that was taken by that Congress was that recent immigrants were removed from eligibility for virtually all federally funded benefits. And instead, Congress placed a new financial responsibility on the shoulders of visa petitioners. So we took away eligibility for means-tested benefits, and we said, sponsors, petitioners, if you are bringing an immigrant into the United States, you have a new financial support duty for that individual. And the vehicle that they used to actualize that public policy decision is the Affidavit of Support. Feel free to ask questions as we go along. My comments usually take about 60 minutes. If I don't get to all the comments, I will answer them afterwards in the chat function. So Congress created a new binding affidavit of support. So those affidavits of support that had been used forever in immigration law, Congress said, we are going to ask what was then INS to create a new binding version of that affidavit of support. This new affidavit of support is required in all family-based immigration cases. This is law, so of course there are exceptions, but in 99% of family-sponsored immigration cases, this thing is required. The primary exception is folks who already have 10 years of work history in the United States. But if you are petitioning for a spouse, for a fiance, for a sibling, for a parent, for a child, you must sign this binding affidavit of support as part of the process, or the person is categorically inadmissible to the United States. It's required in limited employment-sponsored immigration cases, but really what we're talking about here are family-sponsored cases. And yes, I know it's not required at the consular stage for fiance visas, but it is eventually filed in the adjustment phase. So anytime you're talking to somebody who got their green card through a family member, you can bet dollars to donuts that this affidavit of support was signed as part of their immigration process. What does it mean? So this document, the affidavit of support, is a contract between the sponsor and the United States government. The beneficiary is not a party to the contract. But by beneficiary, I mean the intending immigrant. But under the clear terms of the affidavit contract, the intending immigrant is a third-party beneficiary of the contract and has clear enforcement power, clear power to enforce the affidavit of support. And the affidavit of support has been universally recognized by courts as enforceable. There are roughly 175 or so federal decisions on the matter. There are Texas decisions directly on point. I'll go over a couple of those later. But there is no court anywhere in the United States that finds that the affidavit of support is not enforceable. I say that in bold italics because I speak to people almost every week. Spoke to somebody yesterday who goes into a law office and is told, either by an immigration attorney or a general practitioner, that the affidavit of support is unenforceable. And that is not true. No court anywhere in the United States holds that proposition. This is something of an academic point, but you might ask, if this is a contract, what is the sponsor getting in return consideration for their promise? Because as we will see, the sponsor's contract is onerous and it's serious. Well, what they get in return is the ability for their intending immigrant to immigrate, specifically to overcome public charge and admissibility. Because remember, but for the presence of that signed affidavit of support, the intending immigrant is categorically inadmissible. So you, the sponsor, want something. What do you want? You want your family member to immigrate. Well, that person is inadmissible unless the affidavit of support is signed. So that overcoming public charge and admissibility is the thing of value you get in exchange for signing the affidavit of support. This has been tested in courts against the argument that it's an illusory contract without return consideration, and that's been roundly rejected. So there are three things that the affidavit of support requires a sponsor to do. We will go through two of those, which are not the main thing we're going to talk about today, and then turn to the meaty one. One that gets a disproportionate amount of attention, in my humble opinion, is this, that the sponsor promises to repay the cost of federally funded means-tested benefits provided to the beneficiary. So if the intending immigrant during the sponsorship period goes out and gets food stamps, the state, local, or federal agency associated with those benefits can sue the sponsor for the cost provided to the beneficiary. That sounds scary, especially when you think about Medicaid coverage, because if you had a sponsored immigrant who's covered by Medicaid, those could be big bills if the intending immigrant had serious medical care. This is something of a canard because two reasons. First of all, remember that that very same 1996 legislation that created the affidavit of support stripped recent immigrants of eligibility for public benefit programs. So yes, the sponsor is theoretically responsible for repaying these benefits, but it's for programs that the immigrant is not eligible for. So there's a big canard right there. Secondly, simply as a policy matter, I am not aware of a single jurisdiction anywhere in the United States that routinely seeks reimbursement from sponsors. In Washington State, for example, our agency does not even have a policy or procedure for how they would do this if they wanted to. And I'm not aware of a single case in recent history in Texas where this has been done. If anybody knows to the contrary, let me know, I would be interested. But as a policy matter, I simply am not aware of anywhere in the United States where this is done routinely. Trump, for example, considered passing policy that would have mandated agencies to go after sponsors. And even after what I believe we could say were pretty tough on immigration policies in that last administration, even in that environment, the affidavit of support wasn't enforced against sponsors, and that policy never saw the light of day. So for immigration practitioners, when you're telling sponsors about what they're getting into, yeah, you definitely need to mention this repayment of public benefits, but it's also, I believe, accurate to say that it's not something that is done routinely. Secondly, the affidavit of support sponsor has to notify the federal government of a change in address. As far as I know, virtually no sponsors actually do this. There is a provision in the regulations for imposing a fine against sponsors when they fail to do this. I have never heard of that happening. If you have, I'd be interested in knowing. Let me take a quick look at comments, questions before I go on. Okay, yeah, we'll get into res judicata later. Res judicata is a really thorny issue in this world. The main obligation, though, that we want to spend the balance of our time talking about is this, that by signing the affidavit of support, the sponsor promises to provide any financial support necessary to maintain the income of the sponsored immigrant at 125% of the federal poverty guideline. Folks are probably familiar with those numbers if they do immigration law, because you're worried about whether your sponsor meets the requisite threshold to be a sponsor. We're talking about $1,400 a month. This has gone up marginally over the past 10 years, but we're talking right about the $1,400 level. And that financial support duty is what we'll talk about in more detail in a minute. But first, let's go over the duration of the affidavit of support. The affidavit of support becomes a binding contract when it is executed, and the regulations say that executed means it is signed and filed in support of an immigrant visa application or an adjustment application. But the sponsorship duty commences when the intending immigrant becomes a resident. That's a conditional resident or full-blown 10-year green card resident. The affidavit terminates only upon one of these 5 events. The first two were added by statute, and the last 3 were added by regulatory gloss in 8 CFR 213.1.2. Number 1, becoming a citizen. So if the intending immigrant naturalizes, that terminates the affidavit of support. As we all know, you never have an obligation to become a US citizen. That's sometimes a defense that sponsors try to raise in these lawsuits, and they say, well, hey, after 5 years, assuming there's been a divorce, you're eligible for citizenship. Yeah, sure, but you don't have to become naturalized if you don't want to. And plenty of folks, I'm thinking about Indian nationals, Japanese nationals, German nationals, if you don't want to file that weird paperwork in Germany to preserve your citizenship. All those folks often want to remain US residents and not citizens because they don't want to forfeit the citizenship of their home country. So condition number 1 may never happen. Resident doesn't have to become a citizen. Second, the affidavit of support terminates after the intending immigrant can be credited with 40 quarters of work under the Social Security Act. The affidavit of support does not terminate after 10 years. I'll say it again because I hear this all the time. The affidavit of support does not terminate after 10 years. Why? Because the statute and regulations say 40 quarters of work. Well, guess what? If you're not working, you're not making progress towards 40 quarters of work. So if 10 years goes by and a person has had marginal employment, they are not going to reach that terminating condition of the affidavit of support. This condition is extra complicated because the statute contemplates that an intending immigrant is credited with both their own quarters of work and also those of their US citizen spouse if the couple, quote, remains married. So that's a complicated one, especially because this affidavit of support issue typically comes up in divorce proceedings. So an issue that has presented itself a lot of times and for whatever reason has not yet got clear case law on it. What if the US citizen has 40 quarters of work, the couple divorces, and then the immigrant wants to enforce the affidavit of support? Well, sponsor is going to say that you hit 40 quarters of work because the US citizen has 40 quarters of work. The immigrant is going to say, yeah, but we are not, quote, remaining married, which is in the statute as a requirement. There is a very strong statutory interpretation argument on the part of the beneficiary that those quarters of work are no longer imputed, but that issue just hasn't been tested in courts. So I flag it simply as an open issue. But bottom line, condition number 2 here, becoming or getting 40 quarters of work, that may never happen. It certainly isn't going to happen at a date certain, but it might not happen ever. Number 3, if the immigrant both loses residency, I wrote abandoned here, but it could be lost through removal proceedings also. If the person loses residency and departs the United States, that results in loss of the affidavit of support. One or the other, however, of these does not. So for example, I got this question from a judge in Dallas. What if, as was the case in that matter, my client had been outside of the United States for an appreciable amount of time, too long, but she had managed to get back in without being placed into removal proceedings, and they had not started rescission proceedings against her. So yes, she had been outside of the United States, but she had not lost her LPR status. Likewise, if you have a situation, which happens all the time, where a conditional resident comes up on the 2-year anniversary of their residency status and whoops, forgets to file the I-751. Well, that person loses their residency by operation of law, but as long as they remain in the United States, the affidavit of support remains enforceable. Condition number 4, I've never seen this happen. If somebody's placed into removal proceedings and goes all the way through adjustment in removal proceedings, that terminates the affidavit of support. However, if you have a situation like I've got right now, where somebody goes into removal proceedings and does, for example, an LPR cancellation, that's not going to terminate the affidavit of support. So you can have a situation where there's a sponsorship. 5 years later, somebody gets a criminal record, gets put into removal proceedings, raises non-LPR or raises LPR cancellation, wins their cancellation case. That person can still go back and go after their sponsor for support. Finally, the affidavit of support ends if the sponsored immigrant dies. The take-home message for this, though, is that none of these events, except for death, is certain to happen. So if you are advising a sponsor, you can't tell them with any certainty when the affidavit of support is going to end. And when you think about the liability of an affidavit of support sponsor, this goes on indefinitely into the future. So that's a long, indefinitely is a long time. The affidavit of support is clear on its face that dissolution, divorce, separation do not terminate the affidavit of support. No court anywhere in the United States has held to the contrary. And this is by far the situation where affidavit of support enforcement arises the most, is in cases of foreign national spouse versus US citizen spouse. You'll see occasional cases of parent versus child, child versus parent, but usually we're talking about divorced folks when this comes up. I don't want to get too into 301 level issues about the affidavit of support. I mentioned the potential or the challenges around imputed work history in terms of meeting that 40 quarters of work. Another issue that is often lurking out there in the background is, now you may not believe me here, but not everybody reports all of their income to the IRS. I was surprised too when I learned that, but it does happen. So usually as plaintiff's counsel, when I'm showing the court what my client's work history is, I rely on their tax filings and usually simply on their social security statement because it consolidates all of it right there. The defendant sponsors of the world always want to argue that my client has been working under the table, maybe driving Uber and not reporting it, or selling stuff on eBay. And that is something of an unresolved question as to what extent federal courts will look at unreported income as making progress towards a terminating event. Another issue, I guess I can't really say this is unresolved anymore because courts have been pretty clear about this, but recall that merely being out of the United States does not constitute a terminating condition. So you'll have cases where you see this a fair amount with Indian clients. Clients will go back and take care of a parent, for example, during a period of extended illness. Can that beneficiary make a claim to financial support for the time they spend outside of the United States? There's nothing in the affidavit of support contract that says you got to be here in the United States. So the answer is yeah. That might be weird as a policy issue because the whole purpose of the affidavit is to ensure financial support of folks here in the United States to make sure they don't become dependent on public benefits. But Congress drafted it the way they drafted it. INS interpreted it the way they interpret it. And there's nothing in the regs, nothing in the affidavit that says you can't get support while you're outside of the United States. Oh yeah, so this is the last kind of red herring issue. I get this a lot from non-immigration lawyers. Come on. From non-immigration lawyers who defend these. So a lot of times if my client, the plaintiff, has gone from CLPR, conditional lawful permanent residency status, filed their I-751, become a non-conditional resident, defense counsel will argue that that constitutes a change of status or adjustment of status. Both of those are wrong, of course. Change of status refers to going from a non-immigrant status to non-immigrant status. Adjustment refers to initial acquisition of LPR status. And this is just a red herring. Going from CLPR to LPR status does not terminate the affidavit of support. You remain in one uninterrupted status as a US resident. But regardless, remember that the affidavit starts when you get residency and it ends upon those 5 terminating events. So even if you lose residency, that doesn't matter for purposes of the affidavit of support. But let's get into the fun stuff, which is how you, as the intending immigrant, now resident, how you enforce this thing. As I mentioned, there are 150 when I wrote this. Now it's probably 175 or so. About 175 district level decisions that have looked at this in various aspects. There are 4 circuit decisions, most recently the 11th Circuit. I'll get to this later, but it was the 11th Circuit. The 11th Circuit, in the case called Belovich, held that there are no defenses to liability under the affidavit of support, aside from showing that one of the 5 terminating events has occurred. That's a big one. We'll get into that in a minute. The paradigmatic situation where this comes up is what I mentioned. In divorce proceedings or following divorce of a party. Usually, not always, usually these are relatively short duration marriages where foreign national comes to the United States, things go badly, and the couple separates. The reason you get somebody looking at the affidavit of support is if they are broke. So if you are employed, even if you're working full-time at McDonald's, you're probably earning more than 125% of the poverty guideline. And by virtue of that, you're not going to have a claim. So who we are talking about here are people who are unemployed and desperate. So this is a situation where this is their last lifeline for support. Remember that these folks are not eligible for means-tested public benefits. A huge, disproportionate number of folks who end up as plaintiffs in these cases are survivors of domestic abuse, often in really bad situations. One thing that I see happen a whole lot in South Asian clients is they will come over here and it's a situation where the husband is abusive and then also they're living with husband's parents and the parents are making really unrealistic demands on the foreign national. So not without exception, but by and large, these are sympathetic folks who are really down to their last lifeline when they have to turn to the affidavit for basic financial support. And remember, 125% of the poverty guideline. We are not talking here about folks who are getting rich off this litigation. This is a lifeline to provide bare minimum support so that they can meet the most basic necessities of life. When it comes to enforcement, I hear this all the time. The affidavit of support is a federal issue, a federal immigration issue, and so you got to go to federal court. That's not the way civil procedure works, right? In our system, we have the presumption of concurrency. This means that if a federal statute, as is the case here, creates a private right of action, the presumption is that a state court of general jurisdiction has authority to hear that claim. Classic example of this would be 1983 actions, civil rights actions. It's a federal statute. You can go to federal court, you can go to state court. So it is a red herring to say federal law, therefore federal court. We just saw an example of this in Illinois in the, I forget if it's Bicina or Bicina, Russian plaintiff. So in Bachina, the plaintiff, in that case, a petitioner, was in divorce proceedings, and her attorney, Julia Bakova, walked into a family law court and pled a breach of contract cause of action in her petition. And the court in that case just said, no, that's a federal issue. I don't want to deal with it. And she took it up on appeal, and the appeals court said, no, you can't just do that. For state court of general jurisdiction, and family law courts are a division of state courts of general jurisdiction in every state I'm aware of. And so you got authority as a court of general jurisdiction to hear claims, including breach of contract claims. And so it was clear error to simply write this off as a federal issue. But let's talk about federal court. So the vast majority view is that this is a federal cause of action. The federal statute at 8 USC 1183 AE1 creates a cause of action. And so almost all federal courts have had no problem saying that creates federal question jurisdiction. But the flip side of that obnoxious family law perception that I was just talking about is that two federal courts, Middle District of Florida and District of Colorado, have both said that this is a breach of contract action, and breach of contract claims don't fall within the parameters of federal question jurisdiction. That is a wildly incorrect legal proposition, in my humble opinion. That Middle District of Florida case that I mentioned was excoriated by a later decision in the Northern District of Florida that said for a federal statute to create a federal question jurisdiction, all it's got to do is create a cause of action. And look, you got a cause of action right there. So for virtually all courts, this has been a no-brainer. I've never had this questioned in a federal court in Texas. But there is a non-frivolous argument, I guess, that federal courts lack jurisdiction over the federal statutory claim. I think that's crazy, but I acknowledge it is an issue that does exist. But again, going back to state court, it's just a contract. So even if you forget that the immigration and nationality exists, if you just look at the four corners of the affidavit of support, it's an enforceable contract. So sometimes when you see folks enforce this in state court, they won't even mention in their petition the regulatory or statutory provisions around the affidavit of support. They'll just attach a copy of the affidavit of support that's signed and dated and say, hey, judge, look, this is a contract. So that's subject matter jurisdiction. As to personal jurisdiction, the affidavit of support, and this is again, as is the case for a lot of these legal propositions, this is in the affidavit of support contract, it's in the regulation, and it's in the statute. All of those things say that the sponsor waives objections to personal jurisdiction. If we want to get hyper technical, it doesn't specifically waive as to venue and forum. So I suppose an affidavit of support sponsor could try to raise a inconvenient forum objection. I think that's a loser, though. Basically, what this means is that if a court has subject matter jurisdiction to enforce the affidavit of support, it also has personal jurisdiction. That's important because folks often move around after a divorce. And so if you are a plaintiff living in Plano, Texas, and your sponsor's, down in, over in Delaware, you can haul that sponsor into federal court in Texas, no question. And we did that to a Delaware defendant. Now, how about divorce case? Sorry, I'm looking at like two different PowerPoint screens here. So I mentioned that this most often comes up when there's a divorce proceeding going on. Can you get it into family law court? Texas is one of the Actually, I guess it is the state with the most appellate decisions on this, come to think of it. Only one of them is published, but it is clear in the state of Texas, following the Kamali decision that I'll mention in a minute, that a family law court can enforce the affidavit of support in the context of the divorce proceeding. That is great news for an immigrant who wants to enforce the affidavit of support, because if you're going through divorce anyway, it gives you a forum to get in there and enforce your rights. The caveat is that, God bless them, family law judges deliver some real mixed results when it comes to enforcing the affidavit, much more so than federal court. And I hate putting a bunch of stuff on a PowerPoint, but folks always want to ask for the PowerPoint so they can have the citations. So if you want the Texas citations, here they are. I sent the PowerPoints through the chat function earlier. So if you want to download these and have access to the citations, there you go. Excuse me. So matter of Kamali is a good example of how these enforcement matters go sideways in family law court. So recall that the duration of the affidavit of support is unlimited or indefinite. So the court in Kamali said, trial court said, I get it. This affidavit of support is clearly enforceable. And, you know, for factors of equity, et cetera, I'll give you support for 36 months. Which is par for the course with how this goes in family law court, because family law courts are used to looking at multifactorial decisions when it comes to awarding alimony and considering equity, this, that, and the other. And so through that lens, it seemed natural, I suppose, to this court to limit the duration of support under the affidavit in a way that seemed fair. The appellate court in Texas said, no, the affidavit of support is enforceable and the duration of it lasts until those 5 conditions in the affidavit of support. So it's erroneous to arbitrarily limit this support to 36 months. You would think that might settle the issue, and now courts are going to be rigorous in assigning the duration of the affidavit of support in a way that's consistent with the contract. But I will tell you, from the sidelines, I have seen some real mixed results in family law proceedings. So yes, you absolutely can enforce the affidavit in Texas in family court proceedings. In many situations, that's probably the right way to go. But I'm just warning you that I've seen some real mixed results in terms of diluting the otherwise clear contours of the affidavit right. So one approach that I have taken to avoid that, my admission for the Southern District of Texas is sitting in front of Judge Martinez right now, waiting to get admitted, because I got a case where my client is going through divorce proceedings, but I'm worried about what that's going to mean for the affidavit of support. And I'd rather just walk into federal district court in Houston and file a separate cause of action with a high degree of confidence that the federal court is going to do the right thing and enforce the affidavit of support on its own terms. If someone reaches an agreement, this is a question, to get some support in family law court, can the beneficiary still pursue relief in federal court after the divorce if the spouse has withdrawn the application for sponsorship? Well, I mean, there are a couple of issues there. First of all, you can't withdraw the affidavit of support after the intending immigrant becomes a resident, period, end of story. To withdraw the affidavit of support, you got to do this in writing to the adjudicating officer who looks at the immigration application. Once residency is granted, you cannot withdraw the affidavit of support. In terms of the interplay between family law agreements and also just alimony ordered by the court, historically, it's fair to say that courts will not allow a beneficiary to double dip. So if you get $1,000 a month in alimony, that's going to come off the top of what a federal court will order under the Affidavit of Support. But alimony is now no longer taxable. The Affidavit of Support defines income at 8 CFR 213A.1, defines income in relation to taxable income. So when we say the Affidavit of Support beneficiary is entitled to support at 125% of the poverty guideline, what gets them to that mark or not is taxable income. Since alimony is no longer taxable, there is a clear statutory argument that alimony does not count towards a sponsor's obligation under the Affidavit of Support. That has not been tested, but it is out there, and it is a clear black and white statutory argument that could be made. Okay, and I didn't go through all of the Texas cases, but here's the take home. There are some really weird cases out in Texas. These are all unpublished decisions, by the way, that I'm mentioning here. But there are cases in Texas where the foreign national in their divorce petition says, hey, judge, I want this Affidavit of Support enforced. And the court says, okay, let's enforce it. And then the foreign national says, well, hey, there was this period of time before the divorce when I wasn't getting support. So I want that too. And the appellate court will say, nope, nope, nope. In your petition, you asked for continued support under the Affidavit of Support. You didn't ask for support arrearages under the Affidavit of Support. I guess I remember from law school that we typically do notice pleading, right? Where you basically, in your petition or complaint, just have to put the defendant on notice for what you want. But what you see in the appellate decisions in Texas is a pretty hyper-technical analysis of how these actions are pled. And if it's not to the appellate court's liking, they will, as in that case, not consider the entitlement to support arrearages, and they won't consider attorney fees if you don't clearly ask for it. So if you're thinking about bringing this up in a divorce petition in Texas, give me a call and let's look at the language that you're using real carefully. You can cut and paste from the federal complaint I use if you want, and make sure that you're asking for everything that you're entitled to under the statute. Because there are a handful of decisions in Texas where, man, they will try to limit the duration and scope of what you're entitled to under the affidavit. Be careful. What do you get? So this is, as is often the case in law, clear in principle and complicated in practice. So in principle, you are entitled to the difference between 125% of the poverty guideline and income. That's your recovery. So if the person's been unemployed for 6 months, 6 times 1,416 is 8,000 and some bucks. That's your damages. That is clear in principle. Oh yeah, and specific performance. So what the court will do, I was just talking to a federal judge in Kentucky about this yesterday. So courts will do one of two things. First, you get your damages. So damages are arithmetic. Damages are the difference between 125% of the poverty guideline and your income level. Courts will then either order specific performance of the affidavit, and that will mean typically sponsor. You're going to check in with this person every month. You're going to see what their income has been, and you're going to cut them a check for the difference between what they've been earning and 125% of the poverty guideline. If they're earning more than 125% of the poverty guideline, you don't owe them anything. If they're unemployed, you owe them the full amount. Courts will also sometimes style this as declaratory relief. So the court will enter a declaratory judgment as to the scope of rights under the affidavit and then order the sponsor to remain in compliance. I think that's a difference without a distinction. I had a federal judge out here on the West Coast say, I will not order declaratory relief, and then entered an order of specific performance that was exactly what we would have put in a declaratory judgment. So I don't think it makes a lot of difference. But the bottom line is a judge is going to order that sponsor to remain in compliance with the affidavit of support. So the problem here, one of the major battlefields in these affidavit of support lawsuits is what counts as income. So in a world where the claimant is unemployed, that makes it real easy. If the only money coming in their door is W-2 income, that makes it easy too. But that's not typically the case. Typically a plaintiff in one of these lawsuits has been thrown out of their house by the U.S. petitioner. Remember, often in cases involving domestic abuse. So this person has been crashing with a friend. They've been living in a shelter for survivors of domestic abuse. They're living off of food banks. They're taking loans from their family. They might be panhandling. They're getting money wherever they can to survive. So you end up in these battles, in a lot of these cases, with defendants saying, well, if they get money from their family, that qualifies as income and that offsets my liability to them. Courts have made this, in my estimation, a lot more complicated than it needs to be. And I believe the reason for that is that roughly 56% of plaintiffs in these cases are unrepresented. An additional percentage of them are represented by people who have never looked at the Immigration and Nationality Act before. And what those judges in those cases don't hear is that there's a regulatory definition of income that makes this simple. So you've got one segment of cases where courts look into this crystal ball of equity, as I call it, and they say, okay, the plaintiff is living in a house that somebody let them live in rent-free. Let's consider the fair market rental value of that house to be imputed income. Had a case where this happened in Maryland. So albeit that this person is totally unemployed in the most straightforward sense, since they're living in a house that's been given to them rent-free, we will consider the income of that house to be, the rental value of that house to be income. Courts will do that. There's a court in California who considered the value of food stamps to qualify as income for offset purposes. I am pushing back against that in my litigation as hard as I can, because the regulations have a clear definition of income. Income, as I mentioned a few minutes ago, means taxable income. Why courts have not universally deferred to this, again, is something of a mystery to me. And I, honest to God, think it's because the litigants haven't alerted the court to the regulation. But as we all know who do immigration law, remember all of those nasty uphill battles you fought against Chevron deference? Well, here's a situation where Chevron deference actually helps the immigrant, because legacy INS defined income this way. And so my position is, if you, defendant sponsor, don't want to be bound by this definition of income, that's fine. Tell us why that regulatory definition was arbitrary and capricious and not entitled to Chevron deference. Good luck. For courts that have faced that Chevron argument, this includes court in Dallas, what is that? Eastern District, Plano, Eastern District, Western District, Washington, and one other. All in the past year have held that this regulatory definition governs. Now, that doesn't totally clear all issues, but that gives you a really clear finish line in terms of what does and doesn't qualify as income in terms of defining the obligation. The Affidavit of Support contract and regulation and statute all permit a court to award attorney fees to successful plaintiffs in these actions. I am not aware of a single court anywhere in the United States that has declined to award attorney fees. And you got to, because if the affidavit of support claimant can't pay their attorney fees, they can't bring these cases. You know, to look at the hypothetical that I mentioned earlier, if you got somebody who's been unemployed for half a year, they're only getting $8,400. If this person has to litigate their claim in federal court, you know, take the Fakita case, for example, you're looking at like $20,000 if you're just talking about getting into some settlement negotiations, preliminary motions practice, and default. Attorney fees are big. And so if these plaintiffs can't consistently get their fees awarded, they just cannot afford to bring these cases. All a sponsor would have to do is run up litigation fees in excess of the principal amount, and that would scare off the plaintiff, who then can't pay their attorneys. But thankfully, that doesn't happen, and courts do consistently award fees in these cases. It's the real world. Before you run off and set up your local I-864 enforcement shop, this is the real world, and judges look real carefully at your fee awards. So as anybody who's ever done a successful EJA application knows, you know, the judges will, no joke, go line by line through your fees, and they're going to cut you for something. So this is not simply a matter of you take the case and you know with certainty that you're going to get paid for every dollar of your work at the end of it. It doesn't work that smoothly, but some significant attorney fees are going to be awarded. Historically, courts assumed that standard contract offenses would apply in these cases. So you would get into primarily defenses relating to fraud. I call it the "she never loved me" defense. So in almost every case, seriously, almost every case I do, the sponsor will argue, she never loved me, she only wanted a green card. I got a case where that's happening, and my client's like, I never wanted to leave my home country in the first place. But regardless, you know, there's always this sense that the sponsor was duped into signing the affidavit of support. Historically, courts would at least entertain these defenses. They would fail on their own merits because the fraud argument would go nowhere. But we have a clearer situation now, which is that courts hold, most recently the 11th Circuit in the Belovich decision, hold that affirmative defenses just categorically do not apply, period. So fraud, illusory contract, res judicata, et cetera, don't apply, period. The only way a sponsor can avoid liability is by proving that one of the 5 terminating events occurred. So if you, plaintiff's counsel, sponsored immigrant, litigate these claims, if you got your residency based on family petition and your income has been below 125% of the poverty guideline, you are going to get your judgment. Plaintiffs don't lose these cases on the merits, period. You're going to prevail. So if the march to judgment is what you got to do, you're going to get your judgment. Most cases, as is the situation in civil litigation writ large, settle though, and that's a good thing. I often have to convince my clients that settlement is a good thing. It doesn't mean you're giving up on your case. It means you're winning without a battle, which is what you want. So they typically get resolved one of 2 ways. About half of the cases will resolve in a lump sum payment. There will be a calculation for the support arrearages that are owed, some assessment of what is likely to be owed in the future. So clear case is where you've got a situation where there's somebody in a 3-year degree program. That person is going to need support while they finish their degree program, and then we're going to assume that they'll be able to find gainful employment. So in that situation, you might just stick your finger down on the paper, pick a number, and say, look, let's just call this $65,000 and call it good. That's a certainty that both parties can live with. You got your resolution and you walk away with it. That's about half of cases. The other half of cases, recognizing that the entitlement to support is open-ended and uncertain, we'll do the arithmetic to determine what's owed in past support. And then as to future support, we'll just leave it open. And they will do the same thing that I mentioned you get in your judgment, which is to say we check in every month, we see what's owed for the month, and cut you a check representing what's owed. That often sounds like a good deal, especially to sponsors, because they feel like they're not going to overpay the obligation. The rub is that it is a pain to check in every month and figure out what's owed. There's a lot of oversight. You get attorneys involved. You get disputes over what qualifies as income. A lot of these cases end up back in court. It takes two parties to settle a case, and sometimes the defendants insist on going this way. But I will caution you that this ends up in ancillary litigation pretty often. Nuptial agreements. Can you get out of this in the first place? No, not under the earlier decision. So I know y'all aren't in the Ninth Circuit, but you don't have a circuit decision in the Fifth. The earlier case says that these rights cannot be waived in a nuptial agreement. They can't even be defeated by a judgment in a family law court. The nuptial agreement approach makes sense because the sponsors of the world are usually in the superior financial power situation. So if you could waive this through a nuptial agreement, probably most sponsors would. And immigration attorneys would just have their boilerplate agreement. They have parties come in and sign adjustment paperwork, sign the affidavit of support, and then the next document in the packet says, ha, 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 what the sponsor said in signing the affidavit, we don't actually mean that, and we are going to waive those rights. And courts say, not so fast. Congress put this in as a policy decision to protect the American taxpayer, and you can't, as a sponsor, just do an end run around that because you don't want to live up to that obligation. There's not clear binding case law in Texas on this, but you would be remiss to tell a sponsor that you can waive these through a nuptial agreement. If you're considering doing a nuptial agreement for a sponsor, you got to advise that person up and down that there's a good chance the nuptial agreement isn't enforceable. I realize I have not gotten to all the questions here, and I will just jump in after the talk and answer them in the comments if that's okay. I talk to folks about the affidavit of support real often, and it's usually something of a surprise to most practitioners. I will say that clients I speak to often have gone to local counsel and been told that the affidavit of support isn't enforceable. My gut instinct on this is that this just falls between the cracks of practice areas. So folks who have devoted their lives to immigration law are by and large, first of all, they're humanitarians of the best sort, but they are used to thinking about getting immigration benefits for their clients. That's their job. They're not in the mindset of thinking about adversarial civil litigation against private parties. That's just not their job. Similarly, civil litigators who do wield the battle axe against private parties have never looked at the Immigration and Nationality Act in their life. And so they just have never seen this affidavit of support. And so it's just not on the radar of either group of folks. Quick call to action. If you are a family law practitioner, please screen all of your clients to see if they have been the beneficiary of a family-based petition. If they got residency through a family member, this affidavit of support was almost certainly called. If that's true of the other party, the other side got status through your client may very well be on the hook for affidavit of support. If you see that this may be an issue in your case, give me a call. I am happy to just talk to you about your case. We can usually, the two of us, figure out in about 5 minutes whether this is something you're going to have to contend with. And I'm happy to do that for colleagues anywhere. You don't have to pay me. Just give me a call and we'll talk through some issue spotting in your case. And I think I hit it right on the hour mark. So Amy, I will hand it back to you. I will jump into comments. If folks have any follow-up questions, email me. I am totally happy to do a deep dive into any affidavit of support stuff you want to talk about. This is all I do these days.
Thank you so much, Greg. That was a fantastic presentation, and we greatly appreciate your time and appreciate you adjusting your presentation to cover the entire hour. And we'll make sure your contact information is also in the chat for anyone as well, and your materials are available. We are going to go on an hour lunch break. So I would love to see everyone back at 1 o'clock. We will pick up then and continue